Ladies and gentlemen, welcome to the webinar. Today's seminar topic is how asset protection plans fail. Our presenters are attorneys Gary Forrester and Eric Bowman.
Thank you for the introduction and good afternoon, everybody. Welcome to our presentation today. We are going to be discussing, again, as the title suggests, how asset protection plans fail. My name is Eric Bowman. I am an attorney in Central Florida at the law firm of Forster Bowman, and I am joined by my partner and colleague, Gary Forster.
Hello, how are we doing today?
All right, and we're going to walk through for the next hour some common things that we see in our practice, things that often should be addressed or corrected, or even better, avoided. We won't be on camera the entire time, but we will be here with you presenting, and we'll pop back on here at the end. In the meantime, we are filming live today, and so if you have questions, if you want to drop those into the little question box, we will address those throughout the seminar. We welcome your questions, and by the same token, we will have some time at the end, if we do have time, to address additional questions. And if we don't get to your question during the seminar, please feel free to reach out to one of us either after the seminar or at a later date if you see one of these issues come up. Our contact information is in your invite and is also at the back end of these slides. And with no further delay or ado, even though I'm not sure what ado means, but no further delay, we will now move on and show you our agenda for today. And we're going to discuss basically what is asset protection, and we'll talk about where plans get tripped up, how they get unwound, and the biggie in that arena is fraudulent transfer. So we'll spend some time focusing specifically on fraudulent transfer law, and we'll talk about a few cases that give good examples. And we're going to bring it in with tips for planning towards the end, and wrap up again with our conclusion and any questions that you may have. And with that, I will pass it over to Gary to talk about basically what asset protection is and is not.
So what's important about this seminar is that we accentuate some of the examples of a failed plan. And typically the failed plan really derives from the fact that the client or whoever the debtor is or defendant in a case really approached asset protection as something other than its true purpose. The idea is that we create a structure or we purchase assets that are exempt from creditor claims. It's not hiding. It's this we have here on the slide. It's utilizing existing laws, which involve cases and statutes, and operating in a totally legal and ethical format. We're not running from someone. We're not hiding away things outside of what we think someone would find. In the next slide, you can see what asset protection is not. So basically, what asset protection is purchasing assets that are exempt from creditors, like life insurance or the homestead. It's actually structuring businesses in a way such that a business liability does not affect its owners. Obviously, internal business liabilities are covered with insurance. It's creating an estate plan and trust for your children, if funded properly, are not reachable by creditors of either your children or yourself. And it involves proper titling of assets. It's not this idea that I want to hide things away from somebody ever finding them. The reality in terms of this hiding, there's a picture of Eric on top of the dollar sign. Just kidding. I'm the judge on the bottom there. And so the idea is not, because clients come in and say, well, what happens, how can I be totally anonymous? And the idea is not that you're anonymous. I mean, anonymity is kind of sometimes can be an added advantage in litigation because it's just harder to find people. That's not really a legal advantage though. I mean, someone gets you sat down in an office or in court and they can ask you questions under oath, you basically have to tell them where everything is. There's really no hiding of assets as actually a purpose of asset protection. Even Eric has a case here, this William Reed, and
Yeah,
I think
these
that
guys,
was his accountant friend.
they were
nice
just
winger.
fraudsters there. Reed was actually a disbarred lawyer in Nevada, where I used to practice. Nice Wonger here was a colleague of his. He was a convicted felon. They sold these plans online.
They sold the quote asset protection,
and you will
plans.
see that a lot. You'll see, you can go online. I hear about this all the time. In fact, there's a group, in my healthcare practice, I hear about a group who goes to all the healthcare conventions and they're selling your asset protection plan. You can get it all done for, I don't know, some flat fee price, $1,500, and you're totally protected. It's let's just say
That went on for years.
This isn't going to work. The asset protection group got shut down.
Well, actually,
we see
I
it
think
over
Reed
and over.
went to jail.
Reed went to jail. And as I said, Nieswanger was a convicted felon. They got in trouble for tax evasion, or attempted evasion, tax conspiracy, and identity theft. What we are advocating is really taking your existing laws, regulations, statutes, and well-established legal and ethically proper mechanisms to engage in protection. And the key is to do it when you don't need it, to do it ahead of time.
And so I think the theme of this seminar is when you approach the body of law now called asset protection. There's no law school class on asset protection, but it's kind of becoming a body of law. If you approach it with the wrong intent, that actually leads to how asset protection plans fail. Although these are policy reasons for asset protection, a lot of the law in place really is derived from legislation that is trying to balance some problem within the law. You've all heard of corporations, right? Everyone's heard of a corporation. No one views a corporation as an asset protection vehicle because corporate stock's available to creditors of the shareholders. But the reality is that the corporation is one of the first asset protection vehicles. The idea legislatively and policy-wise was to permit people to form an entity and operate a business free from personal liability, right? So you can capitalize a corporation and start taking on debt within the corporation, and the corporation can fail, but it really doesn't impact, apart from investment in the business, the shareholders. And that's kind of the policy. That kind of became LLCs are similar, but LLCs are generally not available. The equity is not available. Trust law from the 15th century really has to do with transferring gifts to someone to be held by a trustee, which are completely exempt from the claims of creditors. What we're going to go into in some depth is what areas of law protect the creditor when the asset protection plan is approached from the wrong angle.
And we get a lot of questions when we do seminars, not a lot, but we do get the question on a regular basis of, why should this be legal? Why should people be able to take their assets and structure them in a way that they're not available to creditors? And my first response, the first thought I have is, if you consider two people who both come into $1 million. Let's say one person works hard, creates some new invention, maybe a new drug that saves lives, and it generates royalties, and now they have $1 million, and they can do whatever they want with that $1 million. And then you have the second person plays a scratch-off game and wins $1 million. One of those folks can take that money and go blow it on casinos in Las Vegas or partying or do whatever they want, spend like a maniac and blow through the money. And the other one can say, you know what, I'm going to save for a rainy day. And a year later, the person who spent that money's gone. the person who saved for a rainy day, if they get sued, let's say the two of them are in business together and they both get sued, one has cash and they're going to be the deep pocket. So why shouldn't the saver, why shouldn't the responsible party be rewarded with some way to essentially save for a rainy day by taking some of their hard, either luckily or hard-won, hard-earned money and putting it aside? And that's what asset protection allows you to do.
Yeah, and some examples we have here are, to Eric's example, in terms of a saver, we have federal protection called ERISA, which is basically creates a trust for pension plans. So if someone is sued, what's in an ERISA qualified plan is protected from creditors. That allows for the savings type mechanism. In Florida, we have the famous homestead protection. And as we get into some of the ways that a creditor could breach a plan, we'll talk about the homestead protection because it creates a very unique example of an exception to fraudulent transfer. Keep this fraudulent transfer idea in mind. It's moving assets to avoid a creditor. And in Florida, if properly accomplished, the homestead that you live in, that you intend to stay in, is exempt from creditors or liens in general. There's some exceptions, some interesting exceptions. But if you have a house that is not in a municipality, you get 160 acres of homestead protection. And you can actually be running from a creditor, taking exposed assets and buy that homestead. Inside a municipality, you get a 1/2 an acre as exempt. There's really no other protection like that as we get into some of the ways that a creditor breaches a plan. Think about that homestead as an exception to something that a creditor who breaches the plan can reach.
And finally, the point below, if you're in a situation where you have a claim against you, you get in a car accident, you do injury to somebody, even if you have planned and you've set yourself up so that your assets are protected, nothing says that there's nothing that prohibits you if you feel a moral obligation to help somebody, whether charitably or in response to a claim, to do that. The difference is that if you have a properly established asset protection plan in place, you are now the person who's making the decision to guide your own moral compass rather than the personal injury lawyer. And that takes us beyond the questions of ethics and morality. We have legality. Can I move assets? Can I restructure my assets so they're not available to creditors? And generally, the answer to that question is yes, prior to any judgment. Once a judgment is answered, there are restrictions on what you can do with assets. And in fact, if you get sued and you have a judgment entered against you, whether corporate or individually, you will be required by most courts to give up a very detailed facts about what your asset holdings are, and the other side's going to be entitled to those. But in this case here, I can't pronounce the case, although I've cited it for years. The Grupo Mexicano case essentially stands.
That's good enough.
It's Grupo Mexicano. I think it was a foreign company that was involved in a lawsuit, but the issue there was somebody trying to get a pre-judgment attachment, and you hear sometimes of pre-judgment attachments and writs to seize assets or to freeze accounts, but it's a very high standard to do so, and typically in order to do that, a creditor filing that suit is going to have to post a bond, and in many jurisdictions that bond is going to be 1.5 to 2 times whatever the estimated damages are the other side would suffer if that bond is ordered by the court improvidently. In other words, we had a case years back where we froze. There was some money in a bank account, and we got a freeze order because it was subject to some shenanigans by a relative, and so it was essentially $600,000 was stolen. We got the court to enter an order to freeze that account, but in order to do so, we had to post a $1.2 million bond in case we were wrong. But it's a very rare circumstance. Otherwise, the law lets you move assets. There's nothing that prohibits that within the boundaries of, as Gary mentioned, fraudulent transfer law and some other basically fraudulent intent. Okay, on the part two, how plans are unwound. And this is, we'll talk about a couple mechanisms here, alter ego, fraudulent transfer. But the overarching theme here is that if you are acting not with an intent to save for a rainy day, to protect yourself against some unknown future occurrence, but you're engaging in some reactionary measure in response to a claim or a perceived claim, you're going to be at risk. And courts often do not look kindly on that. We do have some workarounds. We've seen situations in the past where folks have had other supervening causes or reasons to move assets. But generally speaking, if it looks shady,
it looks bad, it probably is bad.
Yeah, rethink it. Exactly.
So one thing that you should keep in the back of your mind as we go through some of these slides is the idea of intent. So what will overwhelm these cases in terms of background facts is, what did someone intend to do when they moved an asset from an exposed position to a protected position? When they took cash that they were going to lose, and they bought the life insurance policy, they bought the homestead, they bought the annuity, what was their intent? And as we work through the slides, we'll get into the technical impact of intent. But that is basically what you have to keep in mind. Were people planning, or were they reacting to hide things?
And we had a case that we talk about on that issue that gives you an example a few years ago. So actually, it's several years ago now. This case in Ray Cutelli, some folks filed. Ended up in the Florida bankruptcy court, but they came from California and they were being pursued by a judgment creditor. And so it was a couple. I don't recall if they were boyfriend, girlfriend, or engaged. I don't believe they were married. And one of them filed for bankruptcy. But before they did, they sought out assistance from a lawyer who held himself out as an asset protection lawyer. And there were some emails going back and forth with the lawyer about how to move assets offshore and what to do with certain assets that were exposed to this creditor. And it really looked bad for the person who was in bankruptcy. Now, those of you who are really paying attention out there may say, well, wait a minute, how do we have the communications with the lawyer and the client about what their intentions were? And the reason for that is because in bankruptcy, the bankruptcy court did two things. One, found a crime fraud exception to the attorney-client privilege and allowed the communications between the attorney and client to be exposed to the bankruptcy trustee. And there's also a concept in bankruptcy where the trustee is considered the holder of the debtor's assets. And the court said in this case, those communications pertaining to the debtor's assets were property of the trustee, so the trustee was able to access them. Not only that, even more disastrous for the debtor and the debtor's partner was that the partner's communications were also exposed because they went to the same lawyer. And there's also another concept where if two or more clients engage the same lawyer for advice, each client is entitled to all of the communication between the lawyer and all the clients regarding that subject matter. So the trustee was able to get all of this communication, and it was really a disastrous situation for the lawyers. So we want to avoid that. And I mentioned earlier, coming here onto this slide up in front of you here, alter ego. And alter ego is essentially, like it sounds, somebody creates an LLC, but they're commingling assets. They're really not treating it as a separate entity. Sometimes you see this in the context of trusts as well, where somebody creates a trust for themselves and really they have a right to unwind it, but then they get sued and they say, well, everything's in a trust. If it's no matter what the vehicle is, if it looks like it's just your alter ego, there is a legal doctrine that many courts will apply to actually determine that something is your alter ego. And
it's just you.
And you can get whacked.
It's just you. So where this derives from is the corporation. So we're talking to accountants in general, and the accountants know that if you have a corporation and you run all your personal expenses through it, and the corporation's 100% owned by you, and basically there's no division between corporate accounting and individual accounting, it's a very good chance that a corporate debt is going to be attributed to the owner. So whereas the corporation, clients of the corporation, suppliers of the corporation could not reach the assets of the owner in general. In some states, it's quite hard in Florida. In other states, it's easier. You know, the creditor claims alter ego. It's just a guy. There is no corporation, and we're going to go reach his assets. It's a very common claim.
And we're seeing that more, especially again, where you were coupled with nefarious conduct. Courts will look for reasons to find that an alter ego or find some mechanism to reach assets. We see that more and more. Another way courts reach assets that are purportedly protected is through the application of another jurisdiction's law. So you saw on the last slide, there was reference to self-settled trusts. We're in Florida. Florida does not recognize any protective benefit of a self-settled trust. And no, it doesn't matter if it's a corporate trustee or if your pet is your trustee. There's no self-settled trust protection in Florida.
That's a huge amount of misunderstanding, actually, that it provides no asset protection. The self-settled trust, the revocable trust is simply a fancy will.
And so we see folks that have something like that, but there are jurisdictions that protect the self-settled trust and recognize it. There are also, for instance, we see a lot of folks know now that single-member LLCs have exposure in some states. Florida is not a good state to have a single-member LLC, but there are jurisdictions that are. But sometimes people try to use another state's law, and on a case-by-case basis, it may work, it may not. We have two cases here to kind of give an example of where it didn't work. The first one, Huber. I'll let Gary give a little background on Huber. This was a self-settled trust case by a fellow in Washington where there is no recognized protection for self-settled trusts.
Yeah, this was a developer who had I think it was $68 million in development loans, who pretty much knew he wasn't going to make it during the Great Recession. He, in turn, formed a self-settled trust in Alaska. So Alaska has a law, Nevada, Delaware, South Dakota, 16 states. Those are the four very popular states with very protective laws. Say, I can form a trust in your state. I may have to use a trustee in your state, but the law in that state, the state trust statute, says if I put money in the trust, my creditors cannot reach the money. That being said, Mr. Huber formed an Alaska Asset Protection Trust through an Alaska attorney. But what he did was he played around with it. So he was in Washington State. He's not in Alaska. And he had a co-trustee and a protector that had no relationship to Alaska. And the linchpin of these cases is that the accounts, the assets, the real estate, they're not in Alaska. Okay. So the link to Alaska was very thin. That's the first thing when we handle these type of trusts we want to avoid. We want to create a link to the trust jurisdiction, an actual nexus of facts to the jurisdiction that looks like we're using Alaska or we're using Nevada. A lot of times it's not very difficult. At a minimum, you would have a trustee there, a sole trustee there, and a protector there is even better. So Mr. Huber had no link. Now there's a number of cases on these trusts, and there's also a pattern in terms of enforcement. Enforcement, even in our firm, we've had several of these enforced. We've had Florida move to Nevada. We had that enforced. They're enforceable under the right set of facts. What you cannot do is go bankrupt. So when you go bankrupt, all of the law, all the state law, which is kind of black and white, the judges tend to follow the state law. It's a little clearer. When you go bankrupt, all that's off the table. The judge has immense power, and there's a lot of muddied terms like fraud and fraudulent transfer. And so, for instance, if fraud is involved in the discharge of indebtedness in bankruptcy, all bets are off. All the protections can be removed, number one. And number two, a lot of times these fraudulent transfer claims, moving assets away from a creditor, really go away after a statute of limitations period. And in bankruptcy, they extended the period, I think it was in 05, to 10-year look back. So there's kind of like no statute of limitations. So the court basically completely gutted Mr. Uber, pretty much disregarded the trust and distributed the assets to the creditors.
And we saw a similar circumstance in this Wells Fargo v. Barber case. This is one we saw in Florida here. And there, Miss Barber was subject to a claim, I think it was about $61 million as a guarantor on a loan. She was in Florida. Yeah, she actually made a mistake. She sold her homestead, from what I understand from reading the case. She sold her homestead that was protected. She could have kept those funds segregated and potentially protected them for another homestead. There's a mechanism to do that, or a strategy where that would be protected. Instead, she ended up putting them into another bank account in Florida, but then put that bank account in the name of a single member Nevis LLC. Now, you can have a Nevis LLC, and Nevis does protect the single member LLC, but similar to the trust, you have to look at the individual circumstances, and we do those here, but you have to be very careful with them. And the error the big error was that one, she'd moved these assets around a bunch of times. Again, go back to what we said earlier: nefarious planning, intent. If it looks bad, it may be bad. Moving assets doesn't help you. In fact, all it does, it looks like big bright blips on the screen if you have a judgment. And the other mistake she made is putting the account in the name of this trust, and the account was a Florida-based account. So she had no, not the trust, in the name of the LLC. She had no ties to Nevis.
She was also in default on the $64 million,
when she did it.
And she basically, it was totally clear that she was trying to hide the assets from the creditor, which basically is
she lost.
Yeah,
and she lost everything.
So go ahead, Eric.
Yes. Well,
tell how far the court would go.
Yeah. So what the court ended up doing is the court did an analysis and said, well, Miss Barber has a Nevis LLC, but Miss Barber is here in the Florida court. And so she's the debtor, and her interest in the LLC is an intangible interest that carries with her. And therefore, since that interest is here, she's here, I can apply Florida law. It's again under this choice of law issue. I can apply Florida law to the Nevis LLC. Florida allows foreclosure of the single member LLC, and I'm going to allow foreclosure. And a lot of attorneys would have a problem with that because they said, well, this was a Nevis LLC. You have to follow Nevis law under the Internal Affairs Doctrine. She may have had a fighting chance, even if she'd had LLC certificates that were kept in Nevis. We've seen that argument made where somebody says, well, I don't have the stock certificates. They're located somewhere else. That's where the asset is. She didn't do that. She just created this Nevis LLC, or had somebody create it, and sat in court, and the court applied Florida law and was therefore able to allow foreclosure of the LLC. Of course, once Wells Fargo owned the LLC interest in the account, they were able to go in and now exercise rights as the account owner.
But to review that, the court actually decided that the Nevis LLC became a Florida LLC. I, for one, think that that's wrong. They didn't need to do that because what she was doing was fraudulent transfer. And the fraudulent transfer law to unwind these transfers where she moved things into the Nevis LLC, I think the court could easily have linked the fraudulent transfer law to Florida law and allowed for the assets to be unwound. By the way, all the assets were in Florida, so it wasn't real hard for the court. I don't think making the Nevis LLC into, and Eric and I could debate about this, into a Florida LLC was really proper under the law. I think they just could have applied Florida fraudulent transfer law.
So there's a couple ways to get to the asset. The court didn't have a hard time in this case getting there. It was a short opinion. So again, you have to take a look at what your purpose and intent is and how the assets are held. This is the big one this is the issue that we see all the time, is fraudulent transfer. When you get the call, something happened, somebody got in an accident, somebody has a claim, there's a professional liability issue, there's a loan that's not going to be repaid, and somebody's a guarantor, all types of situations. Somebody calls and they're looking for asset protection, and at that point it's too late. And the reason it's too late is because anything you're doing then to avoid a creditor who now has a claim, whether that claim's been reduced to a lawsuit and a judgment or not, once that claim arises, anything you're doing is really going to be under the microscope of analysis for fraudulent transfer. And the fraudulent transfer law, there's a similar law in every state. It varies in certain nuances, but there's a Uniform Fraudulent Transfer Act that's been adopted in several states. Prior to that, there's a Uniform Voidable Transactions Act, and prior to that, Uniform Fraudulent Transfer Act. But in any event, each state has laws that allow protective transfers that are made to avoid creditors to be unwound and put the asset back in the hands of the creditor. And this is the case I referred to earlier. This was this Cutelli case. I already talked about this one. This is where the couple went to the bankruptcy, or one woman ended up in bankruptcy in Florida, and the couple had their asset protection communications with their asset protection lawyer exposed.
Yeah, this is another example of where we don't really, in general, want to go bankrupt. Bankruptcy allows for discharge of indebtedness, but it also exposes the assets. So a good bankruptcy candidate is someone who has a huge debt and did some protection, maybe some small protection, before any of these problems resulting in bankruptcy arose. People who are very wealthy, who have debt, it's very, very uncommon. It is a good idea to go bankrupt.
Yeah, we usually suggest one or the other. Bankruptcy courts are not kind to people who move assets before they go into the court. So when we're talking about a fraudulent transfer and the intent of somebody moving assets, what's your motive? What's your intent once a claim arises? Creditors have two mechanisms to get to a situation where they prove a fraudulent transfer. First is by showing an actual intent, and actual intent is shown by looking at the factors behind the transaction. Look at the bona fides of the transaction. Is the transaction made to a transfer made to a relative or an insider? Is it made after a claim arises? Did you give away assets? Did you try to hide the transfer of assets? These are all what we call badges of fraud. And these badges of fraud, it's a non-exclusive list. You don't have to necessarily prove them all. It's just on a case-by-case analysis. And if you're the creditor proving a fraudulent transfer, the more you can show and the more egregious the conduct, the more likely you're going to prove up a fraudulent transfer by actual intent to avoid a creditor. And then once you prove that intent, the burden shifts to the defendant or to the debtor to show the bona fides of the transaction. Yes, there may have been a transfer for the benefit of a child or a spouse or some other insider, and it may have been a gift, and it may have happened after the claim arose, but there may have been legitimate purposes for that gift over and beyond just trying to avoid a creditor. And we've seen some examples of that we'll touch on as we go through the slides.
Kilker v. Stillman. Oh, the crazy case.
This is a California case where this actually shows this is one of those cases where attitude later counts. The debtor defendant in this case was a contractor. He was an engineer who'd done some site planning work, and the work where he did site planning. There were houses and swimming pools that were constructed, and it failed. He didn't know that it failed.
Well, he had no
knowledge of any
Yeah.
potential claim, but he had, in the meantime, he had done the work. Then he went off and he engaged in some personal planning with an attorney to do asset protection work. Probably by all indications, there was nothing wrong with what he did.
Many years before.
His timing was dead on. He did it long before any claim arose. And after this all happened, and after he moved his assets and protected them, the folks, one of the groups of homeowners, came after him. And so he made a couple mistakes. He first agreed to settle the case and pay him. And okay, I think here on the slide, pardon me. So yeah, so what he did is he moved assets again before this claim ever arose, and he agreed to pay these folks, but he immediately reneged on the settlement. Courts hate that. Courts want their dockets cleared off, and so by him first agreeing to pay and not paying, that really seemed to upset the court. And apparently he was a very bad witness. He had testified essentially in court that he had engaged in asset protection several years prior, and he had no assets beyond $500 in his own name, and he was untouchable. And his testimony was apparently very flippant, or came off that way.
There's nothing like giving the court a challenge.
Yeah, like, you can't touch me. I mean, he may as well have stuck his tongue out and put the little fingers up like my son does. And actually, he doesn't even do that.
And
so,
no, he doesn't.
The nana.
Your little one? No way.
And
no, but this Stillman basically was the site engineer to a huge development where all of the swimming pools basically imploded. So he was sued on this huge claim and just said, you know, you may be able to get me on this claim, but you can't touch any of my assets. And he went in like that. We almost always initially recommend defense of any case. You have to defend the case and show that you may or may not be liable. And then if in fact you lose the case, it's the collection side that where the asset protection comes into play. And you don't need to be highlighting any of your planning or any of your protections or structures that you put into place for several reasons, one of which it's really not part of the initial substantive case. And also, you don't want to bait the judge. You don't want to give people a target to shoot at. And time is passing. In this case, a huge amount of time passed, and judge didn't even care.
Yeah,
do we even know how they broke the statute of limitations? We don't even know.
It didn't. It wasn't clear from a very short, unreported opinion. People say, well, this is an outlier case. It doesn't mean anything. It's in California, which is, you know, has wacky opinions all the time. But really, I think what it demonstrates is two things. One, it sounds like he did what we counsel against. We always suggest that you do your personal planning, your asset protection planning in connection with other updates. Have another reason for your planning other than just hiding assets, not hiding, but other than just protecting your assets even. And what the court said here is that any transfers that he had made for the purpose of avoiding any creditor, known or unknown, is a fraudulent transfer because he did it to avoid a creditor. So simply engaging in fraudulent and asset protection was a fraudulent transfer. That's really a reach. No other case that I've seen has ever gone that far. But I think it's because the guy was probably not the best witness. And in any event, this is a case where the timing was good, but his testimony was bad.
Yeah, it's a good example of what not to do in terms of your behavior. You know, one of the only cases where someone was jailed was a bankruptcy case, and we know some of the people involved in the case, and it really had to do with the fact that this Mr. Lawrence, who was jailed for a period of time in bankruptcy, just flipped his nose at the judge. And he basically had a lot of assets offshore. They weren't reachable, and upset the judge to such an extent that he was held in contempt. He actually kept the assets, but he was held in contempt, and that's much easier to do in bankruptcy. He spent some time in jail.
Yeah, judges, they want their judgments enforced, and they don't like having debtors who are not apologetic. This next case, this is the exact opposite. Stewart is a case that was in the Middle District of Florida back in the early 2000s, 2001 opinion. And in this case, the defendant and debtor in bankruptcy was under a marital support order, but had failed to pay his ex-wife alimony. And when he filed for bankruptcy, he had also, just before that, and while he was in default on the alimony, set up a trust for a child from his second marriage. And the child was born prematurely, apparently. And in any event, what the court said here is that you had to consider the debtor's intent and make a subjective evaluation of what the debtor's motive was. Even though the timing was bad, he had another reason for doing what he did, and that was that had to do with this, setting up a trust for the long-term protection of the child born prematurely. And there, the court found that with these legitimate purposes for setting up the trust, he didn't act with an intent to defraud creditors, and the court let him off the hook.
Yeah, you have to give the court a reason to let you off the hook. I think a lot of these cases, there's several cases like this with these other purposes for the transfer. You always want to have another purpose, a basic purpose, even when there is no fraudulent transfer involved. You're just planning, you're doing your estate plan, you're doing your asset protection plan. It's very easy to combine the two. You're updating your corporate structure. In these cases, it's more of a situation where someone is, in my opinion, reacting. They have a problem. They're exposed. It kind of is a fraudulent transfer, but for the right reasons. You know what I mean? Like they are moving something out.
You always have to have a reason for what you're doing. You have to have a reason, and it can't be to avoid a creditor, even if the timing is right. Now, if the timing's wrong, then you're very likely you're going to be toast unless you really have a good reason. We've seen a couple cases. The Stewart case is a good example. Whenever you're doing something to protect your kids, or if you have like a national emergency, like we've seen in the past, where there's people, it puts a scare into people. That's an opportunity. It's one of those times when you reflect, in any event, on how well protected you are. You think of your estate plan and your life insurance and other insurance, and just protections for the people that you care about, and those types of things give you an opportunity to really engage in some protective planning, because you got legitimate reasons for what you're doing. So now we're going to we've talked about actual fraudulent intent under the statute, and that's a subjective analysis. We also have this constructive fraudulent intent, or constructive fraudulent transfers, and this is really an objective analysis that involves taking a look at whether a transfer is made for less than reasonably equivalent value, and if that transfer leaves a debtor insolvent. Here's the elements here on the slide. One, when we're looking at solvency, we're generally looking at a balance sheet test. Another way to look at insolvency is whether or not you fail to pay your debts as they come due, and then unreasonably equivalent value. It's not market value. It's not fair market value. It's what is reasonable under the circumstances. So again, it's a little bit of subjectivity in the analysis, but overall, this is really just checking the box on these elements, and it gives creditors a mechanism to unwind transfers without going through the badges of fraud analysis.
So what Eric's saying on this badges issue is that practically it can be very, very difficult to prove, even with these badges, like was he running away? Was it the last dollar in his bank account? This type of thing. What you're proving is what someone's thinking. And litigation people will consistently tell you that it's very hard to prove what someone was thinking, that they intended to move the asset away from this creditor that sued them for collection. So constructive fraudulent transfer allows the lender, the creditor, to prove intent without showing what was going on in the debtor's head. A lot of times we see that the creditor doesn't even bother trying to prove actual intent because it's so hard. So they go right into this constructive fraudulent intent, fraudulent transfer analysis by showing, okay, look, debtor moved all the assets into a multi-member LLC owned by a trust, or debtor moved all the assets into a self-settled asset protection trust. And so what the proof, the level of proof is actually pretty easy. So a lot of times we find some of these homemade plans where someone's had problems. I'm going to give the asset to my cousin. Well, you're going to run headfirst in constructive fraudulent transfer because you didn't get anything back. But even if you go and you say, I'm going to fund an LLC, I get the LLC equity back. So I got back reasonably equivalent value. Unless you're dealing with a Nevis LLC where we try to avoid all of these creditor remedies, protected assets don't count in what you get back. So not only does it not count, when you look at insolvency, which is assets versus liabilities, probably a few people in the audience have heard of that, debt versus assets on the net worth analysis, protected assets aren't considered. So it's pretty easy to prove constructive fraudulent transfer if someone dumps everything into a protected asset or gets back an LLC or a trust interest, because that stuff doesn't count in the net worth analysis. Now, what Eric's going to go through on some of these further slides is, how do we value what we received and what was given away? And what are some of the strategies that we can use if a client comes in and they've made transfers with potential insolvency issues?
And another way to think of the balance sheet test is it's from a creditor standpoint. So, if the creditor is worse off after the transfer, according to the balance sheet, then you have a potential fraudulent transfer issue. There's several valuation mechanisms. We've done an entire seminar on just evaluation issues. But if you think of how a disputed contingent claim or a contingent asset, something that may or may not come to fruition, how it may be reflected on a balance sheet, it presents opportunities to potentially plan around some sticky situations. And the best way to kind of show an example, just in simple real estate valuation, is through this Hamilton, BB&TV Hamilton Greene's case that came out of Florida a couple years ago. And this is really something that was relevant to the downturn that we had in the economy back from 2000. Real estate took a dive all over 2006 going forward for several years. And under this case, it was a development loan where there was a $3 million construction loan default. And the bank sued, of course, the developer and all the loan guarantors. And about 6 months later, after the lawsuit, one of the guarantors, Mr. Ballinger, created an offshore trust and transferred the majority of his assets, nearly $1.7 million, into that trust. And so it looked like a straight up fraudulent transfer. And this went back and forth to court a couple times. And the bank had gotten a judgment, of course, because they foreclosed on the real estate, and the real estate, there was a deficiency. So that's when you foreclose on.
Well, the real estate had no value.
Yeah, the real estate was done because of the market. So what was maybe, could have been a $20 million piece of property now is worth, nothing. So the bank has a almost $5 million deficiency judgment. I actually had a client.
We had a case like this.
Yeah, we had a client that had a property that he purchased with about a $900,000 loan that was foreclosed, and in the foreclosure sale, it didn't sell, and the value assigned to it was $20,000. So it was a big deficiency.
True story.
But at one time, it did have value. So what Mr. Ballinger said in this defense to the fraudulent transfer action on his $1.7 million trust creation here is that he gave a couple of things. One, he created this trust. He had good reasons to create the trust, and it was to protect assets, not to avoid a creditor. Think about that one for a second. We'll come back to that maybe. But he was one of several guarantors, and there were many other guarantors who had apparently agreed to indemnify him in the transaction. And so he told the court that he had no reasonable expectation he would ever owe any money, because the other guarantors were out there to indemnify him and help pay for the debt. And the property in question was valued substantially higher at the time the action was filed. So they actually thought they had that they had equity in the property. So when there was a foreclosure, they were expecting the money from the property foreclosed upon would be sufficient to cover the judgment, and it wasn't. But it presented an interesting argument because he looked at the valuation issue from the time the suit was filed and at the time of the transfer. And with these very good arguments, I imagine he had very good counsel in this case. He was actually able to get a favorable opinion from the court. He gave the court something to hang its hat on with respect to the value of the property. He had the other guarantors, and then he had other subjective reasons other than avoiding a creditor for the transfer. And he was
had like
successful.
Health issues, etc.
Yeah.
But I thought that was a fascinating case because the counsel went through the elements of fraudulent transfer. And although, on its face, a case like this seems so obvious, the property's worthless, the assets of a guarantor were transferred to a foreign trust. Oh my God, he's running away. But if you work through the technical requirements of fraudulent transfer, which has to do with insolvency at the time of transfer, didn't make any sense because the property still was worth much more than the loan. And the other people involved in the real estate deal, he was a developer. He had very wealthy people as investors that also guaranteed the deal. Really, in light of those factors, he really had no reasonable expectation to think he would ever become subject to a suit.
Yeah, it's really it's an interesting read on that case. There were good arguments presented. Finally, we're going to move into our last topic. We've got about our last heading here. Got just under 10 minutes. We did get a question. I want to hit the question, and the question is: once I have a claim, are my options eliminated? And the answer to that is once you have a claim, it does appear too late to engage in most protective measures and traditional asset protection that we advocate, again, when you don't have any claims. But no, it's not too late to take a look at what your options are. There still are some strategies, as we described in that case with Mr. Ballinger, in the Stewart case. There have been other circumstances. Here in Florida, you can move property into a homestead. You have certain exemptions you can take advantage of. We also advocate, in that situation, figure out what's exempt, figure out what's exposed, and burn off your exposed stuff and preserve your exempt stuff. If you got to pay your bills out of an account, try and pay them out of something that a creditor can get anyway, because lawsuits are long and expensive. So I hope I answered that question. If you have any others, shoot them over to us. Finally, tips for planning. Again, I think we've driven this point home here. Incorporate your planning into other planning. Right? So what's the motive? What's your reason for doing it? For advisors in particular, if you have questions about what your client's motives are, some folks will advocate obtaining an affidavit of solvency to make sure, and I throw out there that there are cases where lawyers, accountants, bankers and banks, financial advisors have been sued as accessories to a claim on a fraudulent transfer with various degrees of success. Florida, that claim has generally failed. We do a whole seminar where we talk about that issue as part of an ethics seminar. It's actually quite colorful and entertaining. If you're interested, let us know. We can come present that.
And you also have to keep in mind that if you get involved in this type of transfers or an accounting or evaluation, that your correspondence with the client is likely available to the court.
That's a good point.
As soon as you get away from attorney-client privilege, there is an accountant-client privilege, but it's much less protective. A lot of this stuff really should be run through the law firm. At a minimum, the accountant would be retained by the law firms, similar to a tax litigation matter. This stuff becomes very nuanced and detailed in terms of the law. And we take calls and we invite calls at any time associated with any of this type of plan.
Yeah, especially if you have questions about something you think might get you in trouble, and helping a client engage in a fraudulent transfer can get you in trouble. I don't care what the cases say. I mean, it can get you in trouble even if you get sued and you end up being successful in the suit. Being sued is no fun. We've talked about some of the valuation issues. Again, it's a topic we could expand on substantially. We did an article for the Florida Bar Journal a few years ago specifically on this issue. So if you're interested in that, please contact us. Legitimate supervening cause. Again, look for life-changing events. You get married, you take on business partners, you lose somebody, your neighbor has a fire, somebody gets in an accident, you lose, there's
National disaster.
National emergencies. We've seen that, recently play out. There's all types of situations that come up all the time, and you want to try to tie in one of these situations. Understand that, again, back to our statement early on, if it feels dirty, if it looks funky, if you can't explain it in a few words, if it looks like a shell game, a court may find that it's a shell game. This Pivarov case, we won't go into the details, but in that case, essentially, some folks owed the IRS money. They moved assets all over the place, and they had a mortgage placed on their condo in Las Vegas, and the mortgage was used as a lien to try and defeat an IRS lien, and it failed. The court just looked at the economic substance of the transaction, didn't care about all the movement, and was not persuaded. And understand the difference between planning, arguing, and analysis. You don't want to be doing all three. We typically start every plan with an analysis and figure out what the situation is. We may engage in planning, we may have to engage in arguing, but we don't want to be defending our own plans if we don't, if in any circumstance where the client might be involved in a fraudulent transfer situation. We will defend plans. We don't have them breached. We'll defend our work. But if it's too late for the client to do anything, you want to be very careful in those situations. And with that, we're at about 58 minutes. I saw another question popped up here, and we will stay live. We're going to turn the camera back on here. And all right, welcome back. We hope that was informative for you. Again, our contact information is on the screen here, so you can feel free to reach out to either Gary or myself by email. Reach out and connect with us on LinkedIn. We do these on a regular basis. We do live webinars. We'll come to your office, especially if your office is in a really cool location like in a ski village. Another question that came in was, so we're in Florida. If I'm in Florida, so we got another Florida listener out there. That's nice to see. Can I, does that mean that I can't use a self-settled trust for asset protection? I'm assuming that's for asset protection purposes. And the answer to that is you definitely want to get counsel involved in that. No, it does not mean you can't use a self-settled trust. It just means you can't create a trust under Florida law. Gary, would you add anything to creating a self-settled trust?
The idea with the self-settled trust is Florida doesn't have one. Okay, so what we have to be careful are the cases like the Uber case, where there's the connection to the self-settled trust jurisdiction is limited. So we always have, if for instance we like Nevada because Nevada has a very strong statute. There's a couple other states that have strong statutes, and so we always have a Nevada trustee. We try to have a Nevada protector, and if you're using a wirehouse or financial planner for the trust to hold liquid assets, you want to open that account in Nevada under a charter bank or a wirehouse charter in Nevada. If you do that and you're not in the middle of a fraudulent transfer, the odds are that strategy is probably going to work. And the reason that strategy comes up is because of the single member LLC issue. So we usually use a family LLC with multiple members, husband and wife, as additional protection. Where we don't have a husband and wife, for instance, and we have a single person and we have a single member exposure, we like to put a self-settled trust in as the owner of the LLC. That's just a little pearl. We'll close it up. We've expended
All
our
right.
time. We appreciate you for
That's an hour. We have a couple more questions. Sorry, we won't get to those today. But if you want to shoot us an email or a phone call, we welcome it. Thank you very much for joining us today, and have a great rest of your day. Bye-bye.
Thank you.